Hi everyone, I'm Kenneth McDonald. We're going to be going through criminal law, criminal procedure. For those of you that are online, I just want you to know that we'll be starting with criminal law, then into criminal procedure, and we'll be doing that for the California bar exam. Please open your BarWinners approach book to criminal law. Criminal law, criminal procedure questions you should review for this lecture are Vicky raped, Polly vehicle code, reds and blues. These questions and answers can be found in your BarWinners question and answer book in the criminal law, criminal procedure section. For the BarWinners cut sheet outline of these questions, you must log in to BarWinners Learning Management System using the login and username provided by the course. Constitutional law question names: Vicky raped, Polly vehicle code, reds and blues. And I'm very excited to be here. I want you all to know that you're going to be taking a little exam come February, and you're going to nail it. And the reason you're going to nail it is because you're going to be more than well prepared, along with the law school that you've been doing for 3 or 4 years and the bar review course. And the sweet thing about criminal law, criminal procedure, it's dead giveaway. Call the question number 1, what crimes? And like in Vicky, they told you kidnap. Huh? Number 2, they also asked about murder. Could we be convicted of first degree, second degree? Call the question 3 had to do with the statement between 2 people. As soon as you read those calls of the questions, you know immediately we're dealing with criminal law, crim pro. There's no issue. All you now do is you divide up your exam accordingly and give forth the appropriate time distribution. Don't go over an hour, okay? So what we're going to do today, since we haven't had a dead body in a while, and we do have Vicky as a exam to talk about, we're going to get right into murder, all right? And what I want you all to understand from the very beginning is murder falls within homicide. Homicide is the killing of a human being by another. Just for sake of how you approach homicide, why don't you think for a moment about the death of Michael Jackson with Dr. Murray? The question when the officers went to the location is, why did Michael die? How did he die? The answer to those questions would be homicide. Those are homicide questions. So if we deal with homicide, we have several issues that we're going to resolve in homicide. And I have labeled that for you guys, cocky boyfriend. These all are potential homicide issues. They may be there, they may not be. It's up to you as a good student to determine if they are there. The C for cocky boyfriend is causation. Being a good student and using Vicky as an example, you will understand that kidnap was an obvious crime. Kidnapping in all of your felony murder rule gets into causation. Let's don't write it twice. Therefore, let's spend causation in a Vicky-style question under the felony murder rule. If it's a non-felony murder rule question, then we would talk causation here in homicide, because what we're going to decide is, in homicide, criminal responsibility. The O is omission. C, under cocky boyfriend, is the corpus delicti rule. K, killing. Y, year and a day rule. B, is there a body? They give you a potential death, but have they discovered the body? Take the people that the husband and wife selling the boat out in Newport Beach about 4 or 5 years ago, and they never found their bodies to this day, but 3 people were convicted of murder relating to it. An issue would be the body. Where is the body? F is fetus. Now, in these kinds of issues, if they're present, let's talk about it under homicide. Unless you have a Vicky question, then you can discuss causation better under the felony murder rule. Okay, so that would be homicide. You resolve this issue and you have criminal responsibility. If the question was first or second degree, and you had a number of homicide issues, the way you could flow right into it is you could call the question first or second degree, but before we can even decide first or second degree, we have to resolve homicide issues of criminal responsibility, and then go 1 into it, 2, 3, and at the end, now you get into first and or second degree. So it would have flown, it would have flowed nicely from the homicide questions into the call of the question. Generally, the call of the question will be something like first or second degree, or first degree and any lesser. Then you know you'll have 4 to talk about. First, second, voluntary manslaughter, and involuntary. This resolves homicide. After we go to homicide, we now know that the person is criminally responsible for the death of the person. Here, potentially criminally responsible for Vicky. So we go right into murder. Murder is defined as killing with malice. You can put a forethought if you want, but if you don't know how to spell a forethought, why worry about it? Just put killing with malice. We all know what you're talking about. Malice is defined as one of 4 man-endangering states of mind. Intent to kill, intent to GBI, great bodily injury, wanton and reckless disregard to life, felony murder rule. Under malice, the malice that requires the most in-depth writing is the felony murder rule. Felony murder. Let's go right into that right now. Okay? Felony murder rule. Did you know that this is one of the 2 mnemonics you can put on the California bar exam after you first have told us the felony murder rule, what it is? You can then use FMR as a mnemonic for the felony murder. Don't use any other FMR unless, and of course, I tell you the other one you can use. Okay? FMR. Now, we're going to define it, right? Killing in the commission or attempt to commit, attempt would be a good one, they like the attempts, inherently dangerous felony. I noticed that on Vicky there was a statement in there, either in the answer, A or B, that it was any felony. It is not any felony. It's an inherently dangerous felony. What are the inherently dangerous felony? Barroom kiss. B, barroom. Burglary. A, arson. R, rape. R, robbery. M, mayhem. K, kidnapping, modernly, and sex offenses, not rape, modernly. Now, in the Vicky case, there was a kidnapping. So what you would then do is, after you defined barroom kiss as inherently dangerous felonies, the next thing we would want to go right into is the felony that we have identified. So whatever the felony is. Now is a good time to talk about it, and under kidnapping, understand that kidnapping is the unlawful movement of one person from one area to another. And kidnapping is unusual because kidnapping gets into certain kinds of intent, whether it's specific or not. Generally, most people are going to say, if the kidnapping is aggravated, it is specific intent because the aggravation will be for ransom. And in this case, with Vicky, ransom was the purpose, so it would be with the specific intent, and that would be under ransom. So you define and talk about the felony. What they like to do is give you a felony that perhaps hasn't, or an issue is whether it's been completed. And that is whether the person has reached a place of safety. So after you talk the felony, look to see if they've reached a place of safety. Whoop, making this difficult for people online. Place of safety. That's a great issue that they like to get into. When we finish with the place of safety, look to see who the victim is and or who the killer is in the felony. The victim, if it's the victim that the law was designed to protect, it'll either be the victim of the crime, an innocent third party, or an emergency person that comes by, be it police, fire, ambulance. It may be the defendant. If it's a co-defendant, we're going to say no to the co-defendant. That was the common law. Modernly, we're going to say in many jurisdictions they have expanded the victim to include the co-defendant. In those jurisdictions that do, then you go on. In those jurisdictions that don't, it would end. But in those jurisdictions that do, then you can go on. After we have the co-defendant, we look to see at this point in time whether or not under this particular felony, causation. Causation is a good issue. They love causation. Now, Vicky was a great causation case, right? Because in Vicky, she supposedly killed herself as a result of rape and kidnapping. So that would have been a very good causation issue to be discussed under the kidnapping. And the question's going to be in that is the person, the defendant, responsible because of the death of Vicky? When you commit suicide, there's a good issue that you're not responsible. However, the way the facts seem to talk about was that she was so distraught, having been kidnapped and raped, that she took her life as a result of being so distraught. Well, can we then call it but for the actions of the defendants that would never have occurred? You go through your but-for analysis and you talk about it. You already know but-for from it regarding torts. It's not bad to use that same style of analysis right here, okay? And when you finish the but-for, and then we're going to look to foreseeability. Was it foreseeable? Now, the question in foreseeability with Vicky, it may be foreseeable that that person might rape because that person's a homicidal rapist, right? However, with the felony, all right, depending upon whether you're talking the felony here for felony murder rule, whether we're talking about conspiracy when we get there or whether we're talking about aiding and abetting, the concept of foreseeability is going to change. You will note that in the exam when we get to conspiracy, is it in the furtherance of the conspiracy? And one might argue raping when you're going there to kidnap for ransom, it's not in the furtherance of the conspiracy. But when we get to aiding and abetting, we will see that perhaps the foreseeability is simply it's foreseeable because the person knew this guy was a rapist and was convicted, and therefore it would be. Here, is it foreseeable that the person would be killed? And what we're going to argue here is under the causation for the felony murder rule, it was foreseeable, and we're going to give back the facts. If you then said you weren't sure, you said reasonably it would not be foreseeable, don't write yourself out of the exam, just say however in those jurisdictions that would find it foreseeable, and then go on, okay? So we have finished now basically with the felony murder rule. Now we still have other analysis we have to talk about. The reason we're going into the felony murder first is because it has the most issues. So we always want to do generally what has the most issues so we can make sure if we ever have an issue with time, we never stop in the most issues. We stop with an issue that might be little, not a big one, okay? So we never as a student want to put ourselves in a position where time of an hour becomes critical on a major issue. Don't leave these major ones. Get right to it. knock it right out of the park right from the beginning, so the grader, when they see how well you've handled the major issues, will realize the minor ones toward the end. It's understandable because there's 3 hours and this was an hour, and we understand there was a little bit of time. So after this, we then go to intent to kill. With intent to kill, the issue we want to look to is whether there was a deadly weapon. If there's a deadly weapon used under the deadly weapon rule, and I hope you all don't mind abbreviating, you can't do that, I can since I'm on the board. Under the deadly weapon rule, if the deadly weapon was used to do the killing, the law allows an inference of intent to kill because the deadly weapon is so dangerous, and because it's so indiscriminate, and because it kills. We can infer intent to kill. They like the deadly weapon. After we go through intent to kill, we're now going to look for the wanton and reckless. No, we're looking for GBI. Intent to GBI. Now, the malice for intent to GBI can almost be argued in any death. But the actual intent to GBI that we are looking for is some statement to say, this person really irritated me. I didn't want to kill them. I just wanted to blow their kneecap off. But they missed the kneecap, hit the carotid artery, and the person dies in 3 seconds. Okay? That's your righteous intent to GBI. But this can be discussed in almost any situation. Then we go to the wanton and reckless disregard to life. The wanton and reckless disregard to life is the 85-year-old fella about 5 years ago that drove the car in the Santa Monica when they had the, there you go, all right? And by the way, I didn't say it, but throughout the rest of the time, we won't be taking questions. We'll do that at the end and at the break. But if you see that the professor needs a tiny little bit of help, go ahead and yell out the answer. All right, so farmer's market, 85-year-old guy wipes out what, 10, 12 people? That sounds like a traditional wanton and reckless disregard to life. When we finish with malice, we now decide we go to the greater of the two murders, because once we've done this, we've proven murder. Now the question is it first or second? So let's go first degree. First degree murder. First degree murder can be defined as 1, intent to kill coupled with premeditation and deliberation. That's the definition for one of your first degree. Intent to kill coupled with premeditation and deliberation. 3 issues: intent to kill, premeditation, deliberation. We've discussed intent to kill already. Then we would tell the grader we're going to discuss premeditation and deliberation. Premeditation is a form of planning, calculating. Deliberation is that cool, thoughtful mind. After we talk about the intent to kill, coupled with premeditation and deliberation, and I recommend you giving a separate paragraph and definition for premeditation and deliberation. After we've done this, now what other first degrees are there? Well, felony murder rule. Felony murder rule is first degree. First degree by operation of law. By operation of law, first degree. Today in LA, or Monday in LA, if the jury is being instructed on a felony murder, the jury will be told by the judge, ladies and gentlemen, if you find the killing in the commission of kidnapping, that is by operation of law first degree. Is the judge telling the jury to talk about it? No. It's proven. Do we talk about it? No. We've already talked about it here. We simply say by operation of law. But we have some special killings. We might have a bombing. Boston Marathon, perfect example. We may have a poisoning. We may have torture, or we may have lying in wait, which they like. Otherwise, we can call lying in wait ambush. Make it easy for yourself. If you want the simple one word, let's call it ambush. Bombing, poison, torture, lying in wait, or ambush. Now we've discussed first degree. After we have finished first degree, we go to second degree. Second degree murder. All murder, not first, is second. Is there a discussion? No. We've already had it. Because what's the presumption? The presumption is second degree murder unless you can prove first. You can't prove first. Second. All murder, not first. This right here is murder. You have resolved this. Now the question comes, if it was a call to question that said first or second, or said first degree or any lesser, as soon as it says lesser, you know immediately you're going to have to write voluntary manslaughter and involuntary manslaughter. So when you're putting together your homicide murder, don't forget on your scratch paper to remind yourself you're going to talk voluntary manslaughter and involuntary manslaughter. So let's talk voluntary manslaughter. We define voluntary manslaughter as intent to kill mitigated. What is it mitigated? It's mitigated by heat of passion, sudden quarrel, imperfect self-defense. Now, if you're a good student, and I know you all are, otherwise we wouldn't be here, especially on today of all days, right? So that's a great job so far that you're here today. If you have imperfect self-defense, you will know that as a student, isn't there an issue of perfect self-defense? So that when the time comes for defenses, you will talk perfect self-defense if you have a righteous, imperfect self-defense, voluntary manslaughter. The difference being is whether TARM, the average reasonable man or person, would agree. And that's basically the difference. Therefore, it goes hand in glove together. Let's talk, though, about heat of passion. Heat of passion, sudden quarrel, we basically have four aspects we have to get into. In heat of passion, did the defendant have heat of passion? Was the defendant suffering from heat of passion? 2, would TARP, or the average reasonable man, would they agree with the defendant having heat of passion? He'd come home and see his wife in bed and blows the person away who's in bed with her. Would the average reasonable person agree? That's the second paragraph. The third one, was there enough time to cool off? Did the defendant cool off? Did this killing occur 2.5 weeks later? Was there time to cool off? Would TARP agree? That basically is your heat of passion. Imperfect self-defense is the defendant honestly believed he had the right of self-defense. The defendant honestly believed it, but the average reasonable person, TARP, would not agree. The difference between that and perfect self-defense is that the defendant believed he had the right to use self-defense, and under the facts, the average reasonable person would agree that he also had or she had the right to use self-defense. That's basically the difference. The difference is, what would the reasonable person believe? Therefore, they go together. And sudden quarrel is generally what we think of your bar-type fight, where the factors escalate. And when they escalate, one could argue a sudden quarrel. It's difficult right in a sudden quarrel. I would assume you're not going to get a sudden quarrel if you get a dead body. You're going to get potentially a heat of passion or imperfect self-defense. Now we go to involuntary manslaughter. There's a lot of outlines that talk a whole lot about how we define and get into involuntary manslaughter. It's put there so that you'll understand. You might get a question like that on the multi-state, and they can get into very specific nuances. For you guys writing an essay, gross negligence. Pretty simple, huh? It's a killing with gross negligence. When Dr. Murray gave too much medicine to Michael Jackson, was Dr. Murray acting as a reasonable doctor, or was Dr. Murray acting outside, and was that conduct gross? Clearly, Dr. Murray had it in his interest to keep Michael Jackson alive. He was making, I think, $500,000 a year and was his only patient. He doesn't want to kill Michael Jackson, but at the same time, may his conduct in giving him so much meds have been so out of the ordinary what a doctor would practice that we would call it gross. Could we call it potentially a wanton and reckless disregard to life? We could in a similar situation, but chances are we would argue that the wanton and reckless disregard to life is a bit high, and that under the circumstance, somebody in a wanton and reckless disregard to life is being so reckless in regards to living, the person living, that they care less. Well, Dr. Murray is going to care about Michael Jackson living, but he might have acted in a grossly negligent manner, all right? Involuntary manslaughter. That right there is homicide. Okay? So that's our homicide approach. Now, one thing, and Vicky is an example that the bar loves. The bar loves conspiracy. They love multiple parties. So as soon as you see A and B doing whatever they're doing, you know immediately. You know immediately we're going to be talking about multiple parties. So when we talk multiple parties, we're basically going to put on the side of our notebook, on our note paper, SCA, potentially A. SCAA, and you want to think about writing about these. S, solicitation. C, conspiracy. A, aiding and abetting. The other A is there may be an attempt involved, that it may be present, it may not be. Those are kind of what we call the inchoate crimes you had when you were taking criminal law, that hopefully you can remember, 3 years ago probably, most of you took crim law. If the question is a Vicky, and you read the call of the question, and the call of the question are 3 calls of the question, you know, generally speaking, you're going to divide the answer up into thirds. But if you note there's a multiple party issue, and then you know that there is a kidnapping for felony murder, you know, you immediately go, my gosh, the 1 and 2 are going to take up most of my time. And then the third call of the question got into the randa bruton about co-defendant statement coming in against the other defendant. So in a situation like that where you have conspiracy as well as murder, you have to get to it quicker. So how we're going to get to it, we normally would go through solicitation, and we would say in solicitation, it's a specific intent crime that one person is asking another person to commit a crime with specific intent. Specific intent, asking a person to commit a crime. That merges. It merges with conspiracy. Perfect time now to talk conspiracy. Conspiracy, 2 or more people that get together to commit a crime. So what we're going to look at with conspiracy. Agreement. Did they agree to commit the crime? Take Vicky. They talked about having a kidnapping her for ransom. Clear, they got together and they talked about it. There's an agreement. Did they intend to agree? Sure, they intended to agree, because not only did they talk about it, they went out and they formulated it, and then they got her and they brought her to the house. There was an intent to agree. Now the question is, what was it they were intending to agree? This is the object of the conspiracy. With Vicky, the object of the conspiracy is kidnapping. It's pretty clear. But you may have a situation where there is very little talk because we have the street type of people who say, hey, why don't you meet me at the corner? We're going to go down to Coco's, and you know what we're going to do. We've done it before. Those kinds of things, and you're wondering, what are they talking about? Well, we know what they're intending. They're intending to go down there and rob Coco's. But when they go down to rob Coco's, they go up to the teller, and then they take people into the back room, and then they do things in the back room kind of like what they did in the Vicky situation. So now we may have multiple objectives. We may have a potential commercial burglary. When we get to burglary, we will know the difference between a business and a home. In a minority of jurisdictions like California, commercial burglary is allowed. All other jurisdictions, it's not, it's habitation. But we may have an object of commercial burglary. 2, we may have an object of the conspiracy as robbery. 3, in order to rob the people in the store, was it contemplated they might take everybody into the back room or into a refrigerator? Maybe, in order to facilitate the robbery. Now we have kidnapping. Another thing, don't forget when you're talking about a takeover, we may have kidnapping, we may have false imprisonment. All of those may be under the object of the conspiracy. And wouldn't that be a cool question? Because it would have required you to talk about 5 different felonies. Okay? And when you have a question like that, you're talking 5 different felonies, look to put it under conspiracy. So we don't have to write the doggone 5 questions at the very end and talk about the 4 additional felonies that you didn't write in conspiracy. Talk about them under the object of the conspiracy. Perfect time. After we talk about the object of the conspiracy, there may be overt act. And when it comes to an overt act, we know that common law, not required. Majority now, they look, but on the overt act, basically what we're looking for in the overt act is how far did it go? It doesn't require it to be as far as an attempt, okay? So we'll put down assisted. Once we talk about the overt act, then we're going to look to see if there's a withdrawal. In the withdrawal, the question comes generally for conspiracy. Are they withdrawing from the entire conspiracy, or are they trying to limit their liability? In the withdrawal situation, in order for it to be withdrawal, it has to be communicated. It has to be voluntary, and the person has to take steps to make sure that the crime's not going to be completed. In Vicky, the withdrawal issue occurs after the kidnapping had occurred, after the murder. That's when the person starts talking about he went to the police and wanted to stop. But the crimes had already been completed. With withdrawal, we want to see that there was steps taken to stop the crime from being completed. And in many jurisdictions requires the person to go to the police before the crimes have been completed. So in your typical situation where they went to Coco's, one of the persons that goes to Coco's is going to take off running from the door. Doesn't want to go inside with the bad dude. Usually there's a bad dude, right? A guy who's the homicidal maniac, and that person's going to take over the place. And one of the other persons not real sure, kind of reluctant whether how far he wants to get involved. Then he takes off at the door. Has that person gone far enough for a conspiracy? Sure. Has that person attempted to limit liability? Because when the homicidal maniac goes back and starts raping, pillaging, and plundering in the refrigerator, maybe the person at the front door that took off limits the liability by leaving. May not be a withdrawal, but they may be able to limit the liability. But limiting your liability is whether or not it's foreseeable and in the furtherance of the conspiracy. In Vicky, is it foreseeable that the person would commit a rape on Vicky? I think through the facts we would all say yes, it's foreseeable. The question is, does it further the conspiracy purpose and object? Well, it seems to be, in a way, sort of a gratuitous criminal act. that the person did. Does it further? You know, you might have an argument and you can say, you know, if we commit a rape, the person might be emotionally and mentally subdued, feeling emotionally withdrawn, and therefore more easily to keep in place. And it might be a furtherance. On the other hand, it seems so inconsistent with kidnapping for ransom that one would argue it is not foreseeable. And that would limit the liability. Then we're going to go to aiding and abetting. Aiding and abetting basically is the theory of accomplice liability. Identify the person who's involved as either potentially the principal or the accomplice, but if there are multiple, two of them, call them accomplices and talk about their action. And now we're going to look to the mindset, the intent. And there we're going to talk about a shared intent. Have they shared in the intent? And in this case, have they shared in the intent to kidnap Vicky? They sure did. And they talked about it, and they furthered it. So they shared in the intent. And then under aiding and abetting, we have liability. Well, in the liability for aiding and abetting is whether the crime was foreseeable. We don't have a furtherance of the aiding and abetting objective. It's whether it's foreseeable. So in Vicky, it's foreseeable that the one person knew Vicky might be raped because the person was convicted of a sex-related offense, and then the co-defendant basically begged him not to. You're begging a criminal who has a criminal conviction not to do something, and you are putting them in a very situation where it's very enticing. It's foreseeable that Vicky would be raped. Therefore, holding that person under aiding and abetting, where you may have argued under conspiracy, we wouldn't hold that other person for rape. And then we'll end with attempt. That's only if, in looking over the facts, it appears the crime hasn't been completed. A good time to talk about the attempt would be right here. And in attempt, it's a direct but ineffectual act done toward the commission. Direct but ineffectual act done toward the commission. And if you remember in criminal law books, some of our heroes went to a bank on Sunday. All right, that sort of tells you just the type of heroes that we have in our criminal law cases. They didn't realize that Sunday was closed. Or they go up to a person, and when they go up to the person, they ask for all their money, and the person doesn't have any money. All right, those are typical public defender kind of clients. It's a direct but ineffectual act done toward the commission. It's a specific intent, because attempted anything is specific intent. If in the Vicky situation, a better fact may have been, what if the guy who's the rapist isn't able to accomplish the act? Then we would have had an attempted rape situation, and we would have had a discussion on the difference between rape, the completed act, and general intent, and attempted rape, which is specific intent. And it might have been just an additional cool issues to get involved with. But we didn't have that. But attempt anything, okay? Attempt anything is specific intent. And that's basically multiple parties. Let's go back for a moment to the issue of the crimes under murder. And let's say we discussed murder. Are there some potential crimes that are related, but yet the person doesn't die, and we're going to have crimes like assault? Now you'll note that in your outline, assault is a specific intent crime. And why is that? Because assault can be defined as an attempted battery. Attempt anything is specific intent. However, there are other jurisdictions that define assault as placing someone in reasonable apprehension of a direct or harmful touching. That's not a specific intent. Therefore, assault can be both general as well as specific. After we do assault, battery is pretty easy, wouldn't you say? Battery is the unlawful touching. Look to a battery as being the type of socially offensive kind of touching. Touching in spots and places they shouldn't touch us. And it might not have anything to do with harming physically, but it's an emotional issue, and it can be a battery. After the battery, let's look to kidnapping. Kidnapping, we indicated, the simple kidnapping is movement without consent and taking them for a distance. Question, moving them from the cash register to the refrigerator. Is that enough distance to constitute a kidnapping? It might, especially if it places the person in a greater risk of harm. Would a person be more likely to be harmed at the cash register or in the back room where the defendant has no one around to watch? Chances are the back room is going to give the defendant a greater freedom to do what he wants with nobody watching. Kidnapping. Look to see, as in Vicky, it was for ransom. Aggravated kidnapping. Aggravated kidnapping is a specific intent crime because it's the specific intent to ask for ransom, or it may be to harm them. Aggravated kidnapping. After that, let's look to some possible defenses, okay? Now, I tell you, let's just finish the crime element. Let's finish with burglary, habitation, robbery, and the property offenses. That'll wipe out all the crimes, okay? Habitation defenses, arson, burglary. Those are both habitation. Burglary is defined as the breaking and entering the dwelling house of another at night with the specific intent to commit a theft and or felony therein. Two issues in burglary that the bar loves to talk about. Issue number one, what kind of breaking? Breaking by instrumentality. Remember that breaking? A person, now here's how we distinguish between breaking by instrumentality. Is the instrument used to further entry into the facility? Take a car and a Slim Jim. Slim Jim is that metal thing that goes by the window. What's the purpose of that? To pull up on the wire to get access to the car. That's not a breaking by instrumentality. The breaking by instrumentality is the instrument is used to further the felony inside. So perhaps a long metal arm that goes down and tries to grab or does grab the money, the jewelry, the piggy bank inside, whatever, where there's a lot of money kept. And now they're furthering the felony therein. That's breaking by instrumentality. The second thing they like is they like specific intent. And in specific intent, they like to identify they like you to identify going inside to commit a felony. So a person goes inside the home not to steal, but to burn it down. Not to steal, but to beat up the person inside. Not to steal, but to rape. What's the underlying felony? That's a good time to talk about that particular felony under the issue of burglary. One other thing, remember in burglary it's habitation, majority of jurisdictions, habitation, residential homes, but in a minority, California will allow commercial burglary. Therefore, you can walk into a Ralph's when the doors open up and you can potentially commit a commercial burglary even though, one, there's no braking because they've been getting away from braking. Number two, they don't care about nighttime. And in California, you can do it to a business. Okay? So we'll call that a commercial burg. In most modern jurisdictions, nighttime is done away along with braking. Okay. Now, let's do arson. Arson is the burning of what? Burning of a habitable structure. Therefore, during the summer or now when we have the red alerts and we see that there is a burning of Laguna Beach or something, right? No structures are burned, but there's thousands of acres, and they look and they find the person that did it. What do they usually call that person on the news? An arsonist. Is that person an arsonist? No, because there was no structure burned. But they may define statutorily what arson means, and they expand upon it to be property or, to be wilderness areas, to be things non-structure. But that's not under common law, it's habitation. Okay, let's talk now about property offenses. Property offenses would be larceny, embezzlement, larceny by trick, false pretenses. And a lot of you are thinking, oh my, that's an area that I feel so uncomfortable with. Well, let's see if we can put it together for you in a reasonable nutshell, all right? Let's talk property offenses. Larceny, embezzlement, larceny by trick, false pretenses. Let's just dispose of right now false pretenses and larceny by trick. Almost all the elements are going to be similar in the four. False pretenses. I went down to the Chevrolet company to buy a car. I gave the person a bogus check or a bogus credit card. I committed a fraud. What did the Chevrolet want to give me? Title. What did I obtain from them? Title. How did I obtain it? Fraud. False pretenses. I go to the very same place, but all I want is the Chevrolet for the weekend. I'm renting it. I give them the same bogus type check or bad credit card. But what is it they're giving to me? Possession for the weekend. What's the fraud? I obtain possession of the vehicle by fraud. Larceny by trick. Okay? Larceny versus and or embezzlement. Now, what I do with my class when it comes at law school on distinguishing between larceny and embezzlement, I give them a take-home, and I call that take-home custody versus possession. And if they handle the custody versus possession and look at it, they're going to know quite a bit and feel very comfortable with larceny and embezzlement. Let's just sort of go through that a little bit. I will give it to Ann, and if she can, maybe she can fax it or send it to you guys, just as a way to kind of help a little bit. Okay, I own a company. I want my clothing to be cleaned. I give the clothing to an employee. Am I giving the clothing generally to a high-ranking employee or low-ranking? If it's high-ranking, you want out of that place, right? Okay, it's a low-ranking employee. What does a low-ranking employee obtain from the owner? They obtain custody. Why custody? They obtain custody because the owner wants them to do very little to it. You go into a jewelry store and you're looking at jewelry. Do they give you a lot of freedom to look at their jewelry, or are they all over you like a cheap suit? They're all over you. What are they giving you? Even though they may let you try it on, or they may let you try on the watch, They really don't want you trying on the watch, right? They're giving you at most custody. Okay? So we take the clothing to the dry cleaners. The dry cleaner's the third person. I'm telling my employee to go to the dry cleaners because that's what I want my employee to do. What am I giving to the dry cleaners? I'm giving them the ability to take my clothing for some period of time, usually a day, maybe two, and to wash and clean them, press them, take stains out. I'm giving them authority for the day or two. I'm giving them possession. It doesn't matter when the employee intends to steal. If the employee steals before the third party even gets it, okay, we have larceny. Now, the employee is told to go back and pick up the property. He goes back to the dry cleaners and picks up the property. What does the dry cleaner give to the employee? What I, the owner, gave to the dry cleaner. I gave possession. What does the third party give back to my employee? Possession. If the employee now steals from possession rightfully gained, what has he done with that property? He's converted it for his own. Embezzlement. Okay? I then tell my employee that when you pick up the clothing, I want you bringing it back to my work, and would you put it in my closet for me? The employee along the way, after he picks it up, steals, embezzlement. But then he comes to the closet and he puts the clothing in the closet. He's putting it in the clothing for me. What happens to the legal possession or custody of it? Does it remain with the employee, or does it come to me because it's my closet? It comes to me. It's my closet. Now the employee decides, after being around about an hour, I really want those clothes. Now goes back and gets the clothing. Now the person is making a trespassory taking. That's larceny. Here's where you could get into a little tricky area. If the employee brings the property back to the closet for purposes of putting it in, but really wants to steal it, puts it in there temporarily only because there's a couple other employees in around, and as soon as there's an opportunity, steals it, the theory would be under the theory of embezzlement, because it hasn't actually reverted back to me for my own purpose, because it was put there so temporarily by the employee in order to steal it. Okay? That basically is the distinction between larceny and embezzlement. Okay? So don't allow larceny and embezzlement to get into too much stress with you. All right, now, regarding larceny and embezzlement, let's just talk larceny. If I take the clothing by force over the owner, what crime? Robbery. That's robbery, larceny by force. The robbery issue comes up in the situation where our people went to Coco's, our defendants went to Coco's, and they were going to rob the person at the teller. And as they come in, the teller notices something's wrong because the person has a semi-automatic gun, you know, one of these great big huge Uzis, and go, uh-oh, something's wrong. So the teller begins to back away from the machine, the cash register. Question is, robbery is theft by force from the presence. The question would be, and the issue would be, is when the person backed away, is there robbery in their presence when they steal from the cash register? The answer is going to be yes, because the purpose of moving them away from the cash register was done by the defendant to further the robbery, and we're not going to let the defendant benefit by simply saying no presence, no robbery. Okay? So that would be robbery. So we do the property offenses, we do robbery, burglary. That's pretty much all the crimes, except we may have crimes which are the sort of incidental, but unfortunately they have questioned on some of the past bar exams. Receiving stolen property. All right, the art dealers, okay? Now understand, the receiving stolen property is not a sophisticated crime. I mean, it's a throwaway crime, but it raises certain possible defenses. So, receiving stolen property. It's the taking of property that you know was stolen. All right? The question may be, did you know it was stolen? Were you getting into artwork and things? Did they know it was stolen? On the other hand, a very good issue that occurs that the bar likes is they bring the cops involved. And as soon as the cops get involved, you're going to circle it and you're going to put at some point in the defense, we're going to talk entrapment. But right now, we're going to look at receiving stolen property. What happens when the cops get involved with one of the persons with the artwork and wants that person to help find the bigwig? What happens to the property? Does the property change character? Does it go from stolen to no longer stolen? There's a character change in the property. There's a split of authorities as to whether or not that's still receiving stolen property when the bigwig gets the property that the cops and the other person have set up to get the bigwig. Many jurisdictions say, half of them basically will say yes, the other half say no. But in those jurisdictions that say no because the property changed character, what crime? Attempt to receive stolen property. So if in fact you have a receiving stolen property issue, also on your scratch paper, don't forget attempted receiving stolen property and look for it. Okay? All right, let's talk a little bit about defenses. One of the defenses that the bar likes and could have easily be applied here on receiving stolen property and some of the others is mistake. The bar loves mistake. Mistake of fact, mistake of law. Now, if you get a mistake on the essay, call it mistake. Don't start deciding in your essay whether it's mistake of fact or law. Distinguish that in your analysis. Just call it mistake, because most of the issues you're getting is identifying that it's a mistake. If in fact it is a mistake of fact, and the crime I like to share with my students is statutory rape. We thought the young lady was over 18. We went to a locale, we bought liquor, she had an ID, went into a place that said she was either 18 or 21, and you look at her, she looks 18 or 21. I thought she was older than 17. And the question is that a defense to statutory rape? Okay? Now, it really depends, because statutory rape, if it's a specific intent crime, if it's specific intent, then mistake of fact can negate the state of mind. If it's a general intent crime, then the mistake must be reasonable. And in the fact scenario that I gave you, would it be reasonable? Yes, because we talked about a license, the fact that she looked over 18. It must be reasonable for a general intent crime. Then we have such things as mistake of law, the idea of whether or not legally the person can rely upon a statute, rely upon a published opinion, rely upon the opinion of a lawyer. Can we rely upon the opinion of a lawyer? No. Can we rely upon a posted statute or a governmental agency? The answer is very likely we might be able to rely upon that. And the mistake of law, which generally is not a defense, can be a defense. That basically would be mistake. Area of big defense, and that is insanity. with this defendant's head. The fact's going to be something like, the devil made me do it, or I wanted to get the demons out of that person, so I stabbed him to get the demons out. The demons came out and said, good job. All right, when they start those kinds of words to us that are bizarre kind of words, we're going to circle them. We're going to talk insanity, but we're also going to talk diminished capacity. So on our scratch paper, we're going to put insanity, then diminished capacity, because after we talk insanity, we're going to go right into diminished capacity. On insanity, we're going to give back to the greater those words. What were the words? What were those bizarre words? And those bizarre words get into the issue of mental defect and disease. So we're going to have a paragraph on the mental defect or disease. After we resolve it, the question really comes, is it now insanity? Legally, to have insanity, you have to fall within one of 4 of the insanity tests. Monotony, irresistible impulse, what's that third one? ALI. Now remember I said there were 2 times you can use a mnemonic. You can do it for felony murder. You can also do it for ALI. And then you don't have to decide what is the American Legal or Law Institute. You can just put ALI, okay? And then the third one is the products test. And basically you're going to give a short couple of sentence paragraph on each one of these. Monotony is what we call the right-wrong. And in discussion, it's the most strict test in order to establish insanity. Irresistible impulse, it's just think about what it says. It's so irresistible the person couldn't control their behavior. The product test is a good one that you guys have used before on causation, but for. So we're going to call it the but-for test. And then we're going to discuss in the but-for why it would apply, because but-for the person having a mental defect or disease, they would have been able to have conformed their conduct. The ALI, the ALI is an expansive test. It's a substantial capacity. The substantial capacity test, what does that mean? Good question. Hard to tell. But what we know is from an expert, did they have the substantial capacity? Well, substantial capacity to conform to the standards of society versus right and wrong. Right and wrong, either you know right or you know wrong. It's hard, but substantial capacity. So it's an expansive or more inclusive test. So as you're talking about it, you're just going to say it's a more inclusive test because it talks about the substantial capacity. There's room for disagreement as to whether or not this person was or was not able to conform the conduct, and then you give a brief little scenario on the facts. Okay, when we finished insanity, we're going to diminish capacity. In diminished capacity, it is not a total defense necessarily. Diminished capacity negates, because of a mental defect or disease, negates specific intent. Well, let's take the crime of rape. Would diminished capacity negate the general intent crime of rape? No, it requires specific intent. Would it apply if it was an attempted rape? Yes, because remember, attempted anything is specific intent. Therefore, on an attempted rape, you could use a diminished capacity defense where you could not use diminished capacity on rape if it were the completed act. Diminished capacity and insanity go hand and glove. All right, some other kinds of defenses. Some other kinds of defenses as is labeled in your outline, of cops, we have the defense of criminal prevention, crime prevention, okay? And the question on the crime prevention is whether or not we're using deadly force versus non-deadly force. Look to see the deadly force versus the non-deadly force. And is it used to effectuate an arrest? And if it was the arrest lawful by a police officer or a non-police agent? And if it's a private person, then the private person is in fact going to be treated differently than the police officer, because in many jurisdictions and police officers, you can't prevent them by using a crime prevention, even if the arrest is unlawful. California, you can. In other jurisdictions, you can. If the arrest is unlawful, you can stop it. But in many jurisdictions, if it's an obvious known police officer, you can't stop them from effectuating an arrest. We can a private person. Defense of others. The majority rule basically is that you step into the shoes of the person in the defense of others. And it comes down to is whether or not that person had the right to use self-defense or the right to use the defense. If that person had the right to use the defense, you step into their shoes. You too can use the defense of others because that person could. But in a minority of jurisdictions, and probably the growing trend, is there reasonable appearance? What's the reasonable appearance? If you come onto a situation and it reasonably appears one person is being harmed over another, you can step in and you can defend, even though the person you're defending might have been the aggressor. So the status of the person who is aided is going to depend on whether or not the status is that person had the right to use defense. If the person you're aiding was the aggressor, we have the issue of stepping into the shoes of the aggressor versus the reasonable appearance. Defense of property. Generally, a defense of property, there's no deadly force allowed. Deadly force cannot be allowed, so it's non-deadly force. So what does that mean? What's reasonably apparent to stop the action. If in fact it's at your house and it's a defense of habitation and there is a violent entry, we can use the defense of habitation. But there's probably going to be a crossover with another defense of others and or yourself, defense of self-defense. But crime prevention can, if there is a violent and atrocious act and or preventing a inherently dangerous felony. Self-defense. Self-defense, non-deadly force. In a non-deadly force self-defense, you do not have the duty to retreat. You can stay your ground. Deadly force. If you're going to use deadly force, it requires, number one, that you aren't the guilty or the fault party. Number two, what type of force is being used? Is that type of force imminent for great bodily injury or death? Then you may use deadly force to repel that. You, in that situation, have no duty to retreat. If you're in a retreat jurisdiction, and they tell you that on the exam, they might tell you that on a multi-state question, then in that situation, the idea of the duty to retreat is, number one, we can have a duty to retreat if we can do so without harm to ourselves. Number two, if we're in our home, we don't have a duty to retreat, okay? Otherwise, we would have a duty to retreat. Now, in the self-defense area, the question really they like to talk about is when the person who uses self-defense is the aggressor. So you have a situation where you get into a fight and the person you're fighting is fists, and all of a sudden out comes a gun or whatever, and now it's grossly escalating. So the question is, when does the right of the aggressor have the right to use self-defense? So if I am unfairly assaulting one of you, and I'm the aggressor, and you look and you turn around and you bring out a gun on me, has that been highly and greatly escalated? Yes. Could I then use it against you? Yes, if I first of all withdrew. In other words, I communicated the withdrawal, and then it was escalated, and then I rebuffed the escalation. When we were talking homicide, one of the issues was the cocky boyfriend, and under the cocky boyfriend, the O stood for the omission to act. And we used as the example Michael Jackson with Dr. Murray. Now the question is, how will the state prove that Dr. Murray action of failing to act legally became an act? Well, the way they would prove that, they have to show that the doctor has a duty to act. And in the duty situation, there really comes 4 to 5 types of duties. One is statutorily if they tell us on the exam. Second one is by contract. Very likely in the situation with the doctor, there was a contract for the doctor to take care of Michael. Paying him $500 grand a year or so, you better take care of him, right? So that would be a contract responsibility. There also was the special relationship. Think of the family. And in the situation that you might get on the exam is, what if the family member is a senior? Do we have a family obligation to take care of our elderly parent? Is the parent living in our home? If so, you have an obligation to take care of them. Do you have an obligation to go to a state facility? No, but the state facility is going to be licensed, and they're going to be a contract. So they'll have a contract situation. Another one is you voluntarily undertake. So in a situation where perhaps you're rescuing, and you go out to rescue, and the person sees you, and you're close to rescuing the person, and then you start thinking about it, you go, I really don't like this idea of rescuing, forget this. And you turn around and leave. You may have caused the duty by your action. And then the last one is you place the victim in peril. And if you remember on a crim law, you might have had the case where there was a domestic dispute and the woman or the young lady kicked the guy out of the car who was intoxicated, kicked him out of the car on a windy mountain road, and he was run over. Well, I'm sorry, I'm a public defender, but I still applaud that, you know? You get in a domestic violence situation, you start beating up a young lady, she kicks you out of the car and you get run over. Tougho, tougho. But nonetheless, it would potentially rise with her a duty that she should have perhaps thrown the guy over off the road. Okay. Even so, by doing that, might you still place them in peril? And in certain neighborhoods that we know about in the area of Southern California would be yes, right? So just understand if you cause the peril. And I'm going to go about another 5 minutes. It's 3:15. I'm going to stop at 3:20, have a 10, 15-minute break, whatever Ann says, then come back. Okay? Let me just talk a moment about the state of mind. What are our specific intent kinds of crimes, okay? And Sherry has indicated the mnemonic BATMACS, B-A-T-M-A-C-S. It stands for burglary, with the intent to specifically commit a theft or a felony therein. Assault, attempted battery, versus the assault that's not specific, placing someone in a situation where they're about to be battered, the reasonable apprehension jurisdiction versus the attempted battery. All our thefts, the 4 we talked about, are all specific intent. So that would be larceny by trick, false pretenses, and embezzlement. Receiving stolen property, RSP, as we talked about, is specific intent. Question true-false is murder, specific intent. Now, the answer is going to be no, as false, because only in certain circumstances is murder. Only if it's the express intent to kill. So the question, if the question was worded, may murder be specific intent? The answer is yes, with the specific intent to kill. So first-degree premeditated murder, remember, is defined as intent to kill coupled with premeditation and deliberation, specific intent. Second-degree murder, where you can't prove premeditation and deliberation, but you can prove express intent to kill. Yes, because the express intent to kill. Voluntary manslaughter, how do we define it? Intent to kill coupled with intent to kill mitigated by adequate provocation. Intent to kill. Yes, specific intent. Involuntary, gross negligence. No. Conspiracy. Yes, because conspiracy actually gets involved with multiple intents. The intent to agree and the intent to commit the underlying objective. Solicitation, we said. Solicitation is the specific intent to commit a crime. Although it merges with conspiracy, it is a specific intent crime. Now, our major general intent crimes, which is BIRD, B-I-R-D, is battery, involuntary manslaughter, rape. Remember, rape actually is a general intent, and the depraved heart of wanton and reckless disregard to life under malice. And really, if you think about it, depending upon the malice, it could also be inflicting great bodily injury, because great bodily injury may not be with the specific intent to inflict it, okay? But definitely depraved heart, or what we call reckless disregard to life, however you remember it. Under the issue of insanity, I should have mentioned to you, under the issue of insanity, the presumption is the defendant is sane. The defendant has the burden to establish the defendant is insane by a preponderance of the evidence. And that pretty much is crim law. I'm going to look up one thing that in my mind I had a question on. When we talked about the overt act for conspiracy, I may have misspoken by saying a common law majority. Let me just reiterate. Overt act in conspiracy, the majority rule is that the act need not be substantial. It can just help. It may not rise to the level of attempted, a direct but ineffectual act, but it can just be, but it must still be enough to assist. And it might not be substantial at all. And it will suffice if it's the act of mere preparation. Common law, no overt act is required. So we were correct when we talked about that. Okay, so I think what we'll do now is we will stop. In criminal procedure, as I talk, I'm going to be giving you some cases from time to time on certain points. This is not the time for you to be memorizing cases in one particular subject when we have 12 or 13 to get into. But if in giving you these cases, it sparks your memory and you go, oh, and an easier way to remember that principle is the case, then they will love it if you cite a case. I go through this with my class and I require they memorize cases. And when they get a criminal exam, criminal procedure exam on the bar and they cite cases, I know they're going to do well. Just like I had a student going to the DA's office, I told him about 10 to 12 big cases and cite it, and if you cite it, you're going to wow the person who's grading. And if you can wow the grader at the bar, that's what we're going to do. But remember, this is not the time to start memorizing cases you haven't already memorized, okay? All right, so criminal procedure. Let's start with the exclusionary rule. And the exclusionary rule is going to apply to violations of the 4th, 5th, 6th, 14th Amendment. And it will keep out evidence that would otherwise come in if we can establish an independent violation under the 4th, 5th, 6th, or 14th Amendment. There are exceptions to the exclusionary rule, even if there was a violation. Is there an attenuation? Are there certain facts that so attenuate the violation that the violation is in fact not geared toward correcting police conduct? If in fact the proximity, as in your outline, or their intervening circumstances, or whether or not the misconduct's flagrant or not. If in fact we can show attenuation, then the exclusionary rule would not apply. There are also further exceptions to the application of the exclusionary rule, and one of them is under Wong-Sun. You guys might have heard Wong-Sun, and that had to do with the independent source. Although there was a violation in the Wong-Sun case, there was an independent source, and that independent source, along with the fact Wong-Sun was released from custody and voluntarily came back to the police station, that independent source would be an exception to the exclusionary rule. Inevitable discovery. Inevitable discovery in the Brewer case, which we in law school were calling, and in the law we call the Christian burial case. The independent or the inevitable discovery in that particular situation, the police, I believe it was in Utah, they put a schematic of the location where they believe the little girl's body was buried, and they went through a methodical search on a map coordinates. Eventually they're going to find it, inevitably. So that case, even though the defendant led them to the body, the inevitable discovery, they would have found it. Impeachment, our client or our defendant gets up on the stand, says something inconsistent, it can be impeached with the statement. Police get a search warrant. The search warrant turns out to be in error, but in actuality, was the search warrant such that a reasonable good faith belief officer believed the search warrant was valid? And if in fact that's the case, good faith exception will allow. Now under the good faith exception, look to see if in fact the good faith exception is not there because the action of the police were in bad faith. So what are the four? What are the four that shows potentially bad faith? If any one of these four is present, your argument will be no good faith. Number one, it was so, on its face, the search warrant was so lacking particularity that no reasonable officer would believe it. Number two, the affidavit was so wholly lacking probable cause that no reasonable officer would agree with it. Number three, the officer lied or did a reckless disregard to the truth in the affidavit. And 4, the judge wholly abandoned his or her independence. Any one of those 4 is present, good faith will not apply. Regarding the fact of lying and regarding the fact of reckless disregard for truth, if in fact you're looking at an affidavit and you can see in there a potential for lying or reckless disregard to the truth, circle that, and I want you to put 2 things in your scratch paper. 1, don't forget to talk Leon. It's outside of the 4. And number 2, Franks. It's a Franks motion that today we do, and I will make even myself, and it's a motion called Franks under the theory that the police lied. And if I can show the police lied, I can put on a witnesses, the officer, to show they lied. And if in fact I can prove that there was a lie and the lie was material, then that particular warrant will go back into the judge for a review. They will redact the lie or the reckless disregard part, and the judge will re-review the search warrant to see if in fact there is probable cause or no probable cause. So the mere fact on an essay, on a multi-state, that under a search warrant you show that the officer lied means that you win on the suppression? No. The more correct answer is, provided the lie is redacted and re-reviewed, and then no probable cause. Okay? Don't be quick to jump on that as an answer. It may be a correct answer compared to the other 3, which I know you guys hate about multi-states. But just because it's said that way doesn't mean it would necessarily win. Now, who can invoke the exclusionary rule? And you're going to hear the terminology standing. So let's talk standing, even though we as good students and lawyers know that the standard isn't standing, it's the legitimate expectation of privacy in the area searched. And we call that lepus. This is another mnemonic that you can put on the exam after you originally tell them legitimate expectation of privacy in the area searched. You can then talk lepus. You can do the same thing with ALI after you tell them, and you can do the same thing with the felony murder rule after you tell them. These are the 3 times you can use the mnemonic. Legitimate expectation of privacy in the area searched. Who has a legitimate expectation of privacy? Who has what the courts call standing? An owner or a lessee has standing. An overnight guest has standing. Somebody who's purely commercial in a location does not have standing. But here's the tricky one. It's not uncommon nowadays, and when you all become lawyers, start making your good quality of life income, you may have a child and you may want a nanny. And you may have the nanny come between the hours of 8 and 5. And are you going to give that nanny a key? Of course. And you're going to tell that nanny that the freedom to come and go, to buy groceries, and here's where you can put it, and take care of my child, drive my child from place to place. But maybe the nanny leaves at 5 and they don't spend the night. That's a good argument that that particular person probably has a legitimate expectation of privacy. But the argument would be, we don't yet know for certain. But a good argument is that person has a legitimate expectation of privacy because they're not going to let people inside that house. They don't know. And you know they'll say no. Whereas versus a maid who maybe just comes over for a couple hours. That person seems to be more of the commercial person. So social guests, probably not, unless we could show more like a nanny situation. Now, when it comes to the Fourth Amendment, we're going to look to basically 3 things. When it comes to the Fourth Amendment, we're going to look to see if there's state action, government conduct. These are the things we're going to look for. We're going to look to see if there was a search or a seizure, and we're going to look to see if the seizure or search was reasonable. Now, according to Sherry and her outlines, under the 4th, 5th, 6th, and 14th Amendments, whenever you have one of them, put a little blurb in there that says something like this. The Fourth Amendment is applicable to the states through the 14th. We have a Fifth Amendment. The Fifth Amendment is applicable to the states through the 14th. Sixth Amendment is applicable to the states through the 14th. It's just a little blurb you put in, then it flows right on into the rest of your discussion, because many times when you're deciding between the fourth, fifth, and sixth, it doesn't always flow well on your exam. It seems a little herky-jerky. Well, that's a kind of a nice little tie-in to flow right in. And in the government action situation, we're going to look to see if there is an undercover police informant, a security guard, and we're going to look to see if there's that type of person, and if there is, circle and talk state action. Then what you all want to do is you want to find the facts that establish state action, because we don't want to write ourselves out of the exam. And then we're going to argue both ways, and we're going to end by saying the more reasonable jurisdiction would find state action. Now we're going to look to see if in fact there was a search. Now when we do that, you're going to, as the hint says, you're going to ask yourself as you're reading it, does the person have a legitimate or reasonable expectation of privacy in what's occurring? All right? So here's how we're going to handle that. If a person knowingly exposes things to public, and they hold it out to public, clearly they are not establishing an expectation of privacy. Take the telephone booth, if you guys remember the case of cats. We don't usually have telephone booths anymore, but in cats close the door to the telephone booth. And why would they do that in public? To close the public out. Leaving the door wide open and talking, as you're talking to people, you're then holding it open to the public. But if you close the door, you can show conduct where they were trying to heighten their privacy. If you provide information to a third person, for instance, maybe you didn't know, but maybe you're dealing with in custody and you're talking to an informant or undercover police officer in a jail situation, you're communicating it to third persons. No privacy. Common enhancements for our eyes or ears that generally don't get into specific areas, binoculars, do not rise to the level of invasion of privacy. It can in certain circumstances. For instance, a listening device in the cat's case. Okay, there are some places and things in public that are protected. One of those, and some, let's talk about some of these unique public situations. Trash put out of our house. The trash put outside of our house, there is no privacy in that because we've discarded it. That's a case called Greenwood. If that helps you in your memory, go for it. Otherwise, no. Open fields. And today with marijuana being so prevalent, many people have gone out into the parks or into the services and our natural forests, and they've taken an area and they started growing marijuana. And then they tried to protect that area by putting things around it. Well, under the open fields doctrine, Oliver, that would not be protected. Aerial surveillance and flying over, if it's within 400, outside the 400 feet, navigable airspace, it's not protected. Numbers dial on our phone, bank records generally are not protected. Eavesdropping, that's cats, that's in the telephone booth. But whenever you get a telephone call, think of cats, be it even on a cell phone, or if they're talking, and we hear about it in the news a lot, the Patriots Act, where telephone calls are coming in are domestically snooped by the administration and internationally snooped. Those calls, we would argue, would apply a cat's theory in that the person who's domestically making the call has a reasonable expectation of privacy. Versus I may have less of an expectation of privacy if I'm calling Damascus, Syria. And the idea is I probably recognize if I'm calling Damascus and there's ongoing terror activity, the government has a higher degree of interest in that call than they would if it's a call between here and San Francisco. Okay? And then if in fact they're going to listen to telephone calls, we would expect that there would be judicial involvement in determining whether that call should occur. All right? A search warrant. Dog sniffing. A dog sniffs at the Orange LA airport. If we go to a turnstile with our property and a dog jumps up and walks around and it's off in 10 seconds, that doesn't bother us. But if the police come up and take our luggage so a dog can sniff it, that does bother us. And why does that bother us? Because our luggage is an extension of our person. We don't want people messing with our luggage. We don't want people messing with my jacket. This is my stuff. Don't mess with it, right? Don't mess with me. Now, if a dog came in here and just went like this, we'd look and go, that's pretty cool. But if the dog comes up and they take this luggage and takes it outside, it might be a form of me being taken, and the argument under place would be that it's gone too far, and holding that luggage for half an hour was too far, turned out to be a search. A dog sniffs at a traffic stop. Police, in the Caballas case, write a ticket. And while they're writing a ticket that we would probably all agree is, 5-10 minutes, maybe a little more, we wait while the cops are running our driver's license and checking. A dog comes up during that time and sniffs. The law says that's okay. But if they hold us longer than it takes to whatever purpose they've stopped us for, write a ticket. And instead of 5 to 10 minutes, they hold us for half an hour. The argument would be that additional 15 minutes was too long, became a search, and it wasn't reasonable. Now, there's other things that are sometimes used. Police can surveil on the street. They can follow us. We give up certain degree of privacy when we go on the public street. We allow the police a greater freedom to check on us on the street than we would inside our house. So police can place or use devices to follow us. A beeping device. Knott and Caro talked about a beeping device that the police put inside of a contraband area. And the defendant took that contraband and put it inside their car. Under Knott and Caro, the police could track on the street. In Caro, this bag was put into the house, and the police continued to listen to the tracking device from the house. Now we have a home that's been invaded by a tracking device, and that in Caro was held to be unlawful, and they needed a warrant in order to overhear the tracking device from the home. A similar situation in Kelo was an enhanced heating device that the police used to determine whether they were manufacturing rock cocaine. Kelo said using the device and measuring it outside the home was in fact an invasion of that house. Like Caro, with the beeping from the home, was an invasion. There was another case called Jones. And in the Jones case, a beeping device was installed by the cops on the undercarriage of the car, which means the police had to go to the car, get up underneath it, and install it. Well, the court said that was a trespass to the car. And the fact that was a trespass to the car went too far. And the fact, they had an additional fact, that they listened for GPS device for a month and got thousands of pages. But the greater argument is probably the trespass to the car under Jones. Now, in determining whether a search or seizure is reasonable, what we're basically going to do is we're going to establish who has the burden in a motion to suppress. If the motion to suppress is based on a defective issue search warrant, the search warrant is presumed valid. We, the defense, has the burden to show the search warrant was invalid. Take the Franks situation. In the Franks situation, I'm raising the issue as a defense that the officer lied or reckless disregard for the truth. Therefore, I'm raising that issue. I have the burden to establish it. I establish it, then the court goes forward with their procedures on the Franks motion. Otherwise, you can't just routinely do a search warrant issue if you can't establish any kind of violation. You simply want to do an exploration. You just want to do an exploratory motion. The court's going to say no. You have, because it's presumed to be valid, and to overcome that presumption, you have to show a violation by preponderance of the evidence. Now, if the police or the state says there was no search warrant, and we're basing the search and seizure on a warrantless exception, then the burden shifts to the prosecutor, and they have to prove a warrantless exception. In that case, we have a far greater latitude in doing motions where there's a non-search warrant. Because remember, in the search warrant case, Leon good faith makes for an otherwise invalid warrant valid if the officer acted in good faith. So what does the warrant require? Well, if you get a search warrant, I want you guys immediately thinking, as soon as you get the search warrant, circle that. And in your scratch paper, mention to yourself Leon. You're going to talk Leon good faith at some point. Talk Franks as to whether or not there was the defect, lie, or a reckless disregard to the truth. And now go through your standard procedures regarding a search warrant. Look to see if there was a neutral and detached magistrate that's involved in issuing of this search warrant. Were the items placed where I'm going and what I'm seizing, reasonable particularity, so that I would know where I'm going? There was a case where the officers put a third floor apartment. When they went to that third floor, it turned out there were multiple apartments. The court said it was okay to search the multiple apartments, with the caveat being, the moment you realize you're in the wrong place, you must stop and exit. But while you're there, you don't have to have your eyes closed. Probable cause. Well, under the concept of probable cause in an affidavit, the cases that we got involved in were informants, where there was the talk of the two-prong Aguilar-Spinelli test versus the Gates more modern totality of the circumstance test. In the Aguilar-Spinelli, it's whether or not the informant at the time was reliable, and that the officers had a relationship with them, and whether or not the information they gave was particularly credible and reasonable, that information. If in fact that was present, then Aguilar and Spinelli would overrule, and you wouldn't win in a motion. But if it were lacking, you would be able to successfully overturn that search warrant. But then what do you do in the situation where a citizen contacts narcotics agents, and in contacting them, they say, you know, I know you guys are going to come out to the Jordan Downs housing project. I've lived there 15 years. I live in apartment 102, and in 103 right next to me for the last 3 years, I've watched foot traffic come back and forth. Matter of fact, I've talked to people who have gone in and bought cocaine. I know the person in there by the name of, I don't know, Felix. Felix has been arrested a couple of times for selling. Matter of fact, Felix got out of jail a week ago and he went back to 101 or 102. And I know that there's narcotic activity. The police go out to the location of the Jordan Downs and they see unusual foot traffic. But they don't know for a fact what's going on inside 101. They suspect it. But based on what that informant, who was a person in the Jordan Downs apartment, could the police rely upon that type of information? It sounds pretty credible, doesn't it? It sounds believable. But do they have a relationship with her? No, they don't. But under Gates, the totality of the circumstances, the court says we take all of that into consideration as to whether or not there was probable cause. And what you'll do on a Gates situation is you won't throw out Aguilar and Spinelli, but you won't use that as the bright line constitutional determination of whether it's successful or not. The line will be blurred by the totality of the circumstances. But use Aguilar and Spinelli as a foundational help in establishing the totality of the circumstances. Further, the information must be timely, not stale, but we find even a couple of days or even a week in some of the cases have been determined to be stale. But if you see it's been there longer than what would appear to be reasonable, mention it and talk about it, that it may be stale. Also remember, we're going to at some point talk good faith. The search warrant, if in fact it is written up, it's to be executed. That is, the police will go to the location and they will serve the warrant and they will then search based on that warrant. And the question is, if in fact they're at the location to serve, do they have an obligation to knock and announce their presence and serve the warrant? The answer is yes. If they violate the knock and notice, does the exclusionary rule apply? Hudson says no, the exclusionary rule does not apply. But other cases have said that if a statute claims in drug cases, police have no obligation to comply with knock and notice, that's been overturned. And that was Welsh versus Wisconsin. Now, there are exceptions, and that's, as we know, where most of our issues are going to come up under the Fourth Amendment. What are the exceptions to the warrant requirement? Well, one we know is exigency. And in exigency, we talk about three issues. Do the police believe that there's going to be destruction of evidence? Do they hear telltale signs of destruction of evidence? Are they in hot pursuit of a fleeing felon versus they know that there is a dangerous felon, but they're not in hot pursuit? Take the Dornan situation over the summer, LAPD, right? Out there shooting up people and killing them. We have an exigent situation. But if I'll get to it in a moment on that. When the police sought, they didn't seek a search warrant, they sought an arrest warrant for Dornan. But nonetheless, in that situation with Dornan, would that rise to the level of exigency, even if they're not seeking him, fleeing? They're just hunting him. And it may be not exigency if they're hunting him. Or we may say, since Dornan is so unique and he's killing people and anyone may be a victim, we will give the police an added freedom to go inside a place where we might not otherwise under exigency. Or in the situation where they decided not to even go inside. They just decided to burn the place down, right? And most of us applauded the burning of the place down. So. But nonetheless, exigency. Search incident to a lawful arrest. Now think of the terminology. SILA, search incident to a lawful arrest. In order for a state to justify searching with an unlawful arrest, the arrest has to be lawful. So look to see if that arrest was lawful or not. If in fact there was a lawful custodial arrest, the police have the right to search. They have the right to search the area within the immediate control incident to that arrest. If you're arresting somebody in a home, it requires the minimum of an arrest warrant, not a search warrant. If you go into a third party's home, that requires a search warrant, not into the home of the person that the warrant applies. And in the search incident to a lawful arrest, the arrest must be contemporaneous the search must be contemporaneous with the arrest. We're not going to arrest somebody in a car and then drive 2.5 miles to a home and claim that search incident and lawful arrest allows us to go into the home. To cars. Search of incident to a lawful arrest of cars, the case is a really good one, is called Gant, G-A-N-T. In Gant, there were several people that were stopped. The police believed that and checked the license of Gant, and Gant was driving on a restricted or suspended license. And based on that, everybody was asked out of the car, and Gant was arrested and placed handcuffed into the back of the patrol car. After he was placed back into the patrol car, the police now want to search Gant's car incident to that lawful arrest. Well, it sort of sounds like a search incident to a lawful arrest, right? There was a lawful arrest, appears, and now they're searching the car. But in a search incident to a lawful arrest under Gant, the issue was, number one, normally when we allow a search incident or lawful arrest, when the person's being arrested, they have access to the car. In Thornton and Belton, it was a drug, and they were sitting right outside the car, and they had access to the car. And the courts allowed the search incident to a lawful arrest, almost strip searched the car because we're talking drugs. But in Gant, when the defendant was placed in the back seat, handcuffed of the patrol car, where is there a safety issue for the police to claim we need to search this car incident to a lawful arrest? There is no safety issue. They've taken care of it by putting him in the back of the car. Now, the second thing in a search incident to a lawful arrest, the search has to be based on gathering evidence as a result of the arrest. So if you're arresting somebody for drugs, you're going to look for drugs in the car. What other evidence are you going to look in the car for driving on a suspended license? You're not going to look, and there's no other evidence to find. So therefore, under Gant, they overturned the officers coming back and searching the car after Gant was placed inside the car. Automobile exceptions. If police officers have probable cause to believe there is evidence or contraband in the car, they can search that car. That's an Acevedo situation, where in Acevedo there was drugs placed in a bag, and the bag was watched by the cops. The bag was put in the trunk. They followed the car, they stopped it, they went into the trunk, and now we have them going in and getting the bag inside the trunk. Acevedo said we didn't require a search warrant because the basis of the probable cause was the bag of drugs that they had probable cause to stop and look for that bag of drugs. If the basis of the probable cause was, for instance, we have a coyote from Mexico that's transporting illegal immigrants, are we going to allow the police to stop the car and look inside a jewelry box? Well, what's the basis of the probable cause? Being a coyote, right? Transporting illegal aliens. How do illegal aliens fit inside a jewelry box? No, so the limit and scope of the search is the probable cause itself. Look to the probable cause. Another exception is inventory search. This is a cool one. Regardless of how many, now, another thing to remember, it's not the least amount of exceptions on an exam we find to justify it. It's the most we can show, the greater we know. So we may have an automobile exception. We may have a SELA, search incident to a lawful arrest exception, and we may have a inventory search exception. Inventory search is Bertine. In the Bertine case, the court said, yes, you can search based on inventory if you have in place a set of procedures already there by which you're following. If you have no set of procedures, inventory search is not allowed. Plain view. In the plain view doctrine, it basically implies the police do not have to keep their eyes closed when they go into a location or a car or a body and they're searching. Plain view requires basically two things. Do the police have a right to be there? And number two, do they immediately know it's contraband? Now, nobody's going to want this, and everybody in my class says, Professor, you hold that telephone up. Nobody wants your telephone, Professor. But nonetheless, if I hold this telephone up Can you immediately tell by looking at it whether it's stolen property? No, you can't. But if this were rock cocaine and you were trained and I held it up, you would immediately know that this is rock cocaine. So on a plain view, if you walk in, the police have a right to be there, but the items they see, they have to immediately know is contraband. And if they do, then they can confiscate it based on plain view. The limitation on plain view is we can't go room to room to room based on plain view and take a plain view exception and blow it into a full-blown search. And under the case of Hicks, Hicks was a case where the officers had a right to be in the location, and they said, you know, this is down in a difficult part of town. The people living here don't have much money. And then they see this equipment, this TV and scanning equipment. And they say, wow, that's out of place. And they began to look around this item and they take things off and they're manipulating it. To do that, they're finding the serial number and they call down and find out the serial number this was stolen. Under plain view, when they walked in, they had to, number one, be there where they had a right to be. But did they immediately know this equipment was stolen? The answer is no. They didn't know until they started manipulating it. Hicks says you can't manipulate it. Consent is another exception to the warrant. And in consent, we just have to show actual or apparent authority to give consent. In the consent issue cases, one of the areas that can be a little troubling is when both people have a right to access to the location. And Sherry has called that dueling authority, which is kind of a good explanation. Two people are claiming they have a right to be there. One says go inside and the other person says no. In Randolph, defense attorney who was domestically violating and beating his wife, the wife says there's drugs inside, and the cops knew, both of them lived there, knew they were husband and wife, and the police say, can we go inside? The wife says yes, but from the police car, the defense attorney yells out, no, no, you can't go inside. And the court said, when both people are there who have the right to give authority, and one says no, the other person can't override the person saying no. So in a dueling situation, equal authority, one person can't override someone saying no. Terry stop and frisk. In the Terry stop and frisk situation, we're talking about reasonable suspicion. We're not talking about probable cause. We're talking about reasonable suspicion. And in the Terry situation, they followed the people around and they suspected they were checking out a place in order to rob, and the police, with their experience, said it appeared to them that this is what they were doing. And the idea was they stopped them. They stopped the people, and then they began to search them. They were searching them for weapons for officer safety. In the Terry stop and frisk, if you, the police, have reasonable suspicion that criminality is afoot. Now those are really cool words. They're easy to remember, right? Reasonable suspicion, criminality is afoot, we can stop. Can we search or pat down based on that? Well, it depends. Compare the guy who's they think is about to rob and they're stopping him for robbery versus one of you that might be down at Newport Beach with alcohol in a bag and you got a Speedo bathing suit on. Now, based on that Speedo bathing suit, we can look and know immediately whether there is a... What about arrests in public places? Under Watson, do you need a search warrant to arrest a person based on probable cause in the public? The answer is no. We need probable cause. Now, there was a recent case, King versus Maryland, which was a DNA case in which the officer stopped the person, arrested them for committing a violent offense, took him into the police station. During booking, they did a buccal, B-U-C-C-A-L, swab of the defendant's mouth, compliance with the statute, to do it on every case. All right, and the question is whether or not that was proper. 5-4 decision on that. So that's not a slam dunk. 5 of the justices said it was okay because it was compliance with the statute, the defendant was arrested by probable cause, and it was a violent offense. So they allowed the search. Scalia, who is otherwise pretty conservative, and he was with 3 very liberal justices, Sotomayor, Ginsburg, and I don't know, throw another, maybe so. And and Scalia wrote the opinion for the minority. And he said that was being done to collect evidence of a potential crime. And that's gone too far. So that could be an issue that you might wrestle with if you're given that on an exam, okay? But that was a DNA swabbing under King. The answer is yes. But hey, maybe there's an issue that it goes too far. Now, we have special needs. And the special needs, matter of fact, has been tested a couple of times in the last few years. One of them was the DUI checkpoint, SITZ, S-I-T-Z. A DUI checkpoint, does that have a legitimate state purpose apart from checking for criminality? And the answer is yes. They have a public safety reason for why they want to stop people who are under the influence, because they get in accidents and people get killed. Now, does a drug enforcement, if you're stopping to check for drugs, is that the same as driving under the influence? I don't think so, because in the drug situation, you're looking for criminality. Now, if we legalize, which we're getting close to, marijuana, maybe we might have a DUI/marijuana checkpoint, in which case we're looking for people under the influence, and it might apply. But SITZ was the case on that. What about schools? Is there a heightened reason for allowing police greater freedom to search in schools? Answer is yes, TLO. But what they require is reasonable suspicion. So officers can't just routinely go in and start searching every locker. They have to at least have a suspicion. Drug testing, can they drug test planes and trains? Yes, when they have a heightened reason for wanting to drug test because they carry people. Or in schools, can they drug test? Yes. Search at the airports. Remember place, the dog sniffing. Yes. And there's also the safety factor, which is public safety, quarrels. If you remember in quarrels, the police were looking for a person who had a gun, and they followed him into a grocery store. And in the grocery store, their gun was placed somewhere, and he didn't have them. And they asked, where's the gun? And that was outside of Miranda, but the person answered under safety, they didn't require that person to be Mirandized. We'll get to that with Miranda. Because if you remember the Boston Marathon? And over the television, they kept saying, gee, if we get the Boston Marathon and suspect, we won't have to Mirandize him. There's a public safety exception. And they had the Attorney General and the Assistant Attorney General talking. Not one of them mentioned quarrels. You guys, get that on your exam, mention quarrels. Quarrels a public safety exception. And if you're ever out in public and you have a Boston Marathon, I tell my students, all you got to do is start talking quarrels in the case, and the media will flock to you because you understand what you're talking about. Border searches, we give greater freedom at the border, right? Okay, let's go into interrogations, confessions, 4th, 5th, 6th, and 14th. How those 3 apply. Okay, a defendant may move to exclude a confession on 4 possible grounds. 1, Fourth Amendment, Prohibits confession. That's what's the fruit of an unlawful search and seizure. That would sort of be a Wong Sun kind of fruit of the poisonous tree. 14th, that's when we're talking a due process violation because the confession was involuntary. Fifth Amendment, that's Miranda and all the accompanying information regarding Miranda. And the Sixth Amendment prohibits it when the statement's elicited in violation of the right to a lawyer. Sixth Amendment. Now, under the 14th Amendment, we're looking for coercive police conduct. Now, the type of conduct we're looking for is, there's some obvious conduct. If you take a person and beat them unmercifully, the answer is going to be involuntary. If you remember the Gitmo Guantanamo Bay dealing years ago, and we had photographs of suspects that were stripped naked and were being asked to do some rather terribly derogatory things, and they were doing it to try to get statements from them, right? Well, clearly, doesn't that give the impression of a 14th Amendment due process coercive conduct? And the answer is yes. Now, there might have been some exceptions because military were at state of war, but it wasn't long before the court said, wait a minute, due process requires that a judge determine whether or not these people were there validly or not. So look to a conduct by the police. And it may be lying or it may be promising. Now, the promise versus the lie. The promise may be an act that causes the defendant to feel greater need to talk. For instance, we'll talk to the prosecutor and the police and we'll get you bail. We'll provide this for you. And it's, you only may be facing 2 or 3 years in prison, so don't worry about it when in reality you're facing life. Promises made that can be potentially coercive. Lies. Generally lies are okay. So if the police lie, they do all the time. Said incorrectly. They can, as a technique, lie. And it's not something that is not infrequent. We see it. Miranda. Now, clearly, Miranda, Fifth Amendment, is the biggie. Miranda is going to determine whether or not the statement or confession is admissible. If you have a Fifth Amendment, you're going to put in Fifth Amendment is applicable to the state through the 14th. Miranda, you're going to put that up at the top of your page, you're going to underline it, and you're going to claim that if in fact there was custodial interrogation, that Miranda requires the following 4 rights. Remain silent. The statement can be used against you. The right to an attorney. And if you don't have one will be afforded you. Those rights are required not in all situations. Those rights are required when we have custodial interrogation. Therefore, Miranda easily breaks down into 2 arguments. Custody, and then a break with paragraph or 2, and interrogation. In custody, when is a person in custody? The general rule on when a person's in custody is when the average reasonable person wouldn't believe that they are free to leave. There is a case called J.D. versus North Carolina. And I thought I'd just share this with you. You don't have to memorize it unless you happen to remember JDB. A 13-year-old kid, juvenile, is brought to a room by a uniformed officer, comes to the room at school, and in the school there's 2 detectives, 2 school officials, and a juvenile investigator, 5 adults with a 13-year-old kid. The person is spoken to for half an hour to 45 minutes. Custody? Sure sounds like it, doesn't it? But you know why I'm telling you JDB? Guess what they said? No custody. Because in fact this person was free to come and go. How many 13-year-olds with the door closed would believe they're free to leave with 5 adults? No, so it doesn't make sense, but just understand that's JDB. So that was upheld, JDB, because that's what I just said. Now, interrogation, custody, Reasonable person believes they're not free to leave. Interrogation. What do we mean by interrogation? Innis, I-N-N-I-S, Rhode Island v. Innis, were the statements designed to elicit an incriminating remark. So if in fact you're arrested and the police are talking, and when they start talking, they say, gee, you know, we've arrested this guy for child molestation, and wow, you know what people out there in the community think of child molesters, you know. And now, why would they be talking like that? Maybe they'd be talking like that just between two officers, or might they be talking like that knowing this person wants to talk so as to dispel, one way or another, this idea of being a child molester? Is it designed to get an incriminating response? Or what if the person is sensitive to special needs, people who might be physically, mentally handicapped, and they say, golly gee, you know, we ought to find out where this gun is. You know, there is this handicapped school right here where these poor children may get the gun. And they know the defendant is sensitive to that. They're doing that to elicit an incriminating response. That's the argument you're going to raise. It was being done to elicit an incriminating response. Now, the exception to Miranda, one of the exceptions, is quarrels, the public safety exception. A further exception is the police informant. You're in custody and you're talking to a police informant, or maybe an informant working for this police, an agent. And there's no reason why you or your client even suspects police action. Remember, 5th, 4th, 5th, 6th, 14th are all police and state involvement. If you don't even suspect there's a police officer, that would be exception to Miranda. Now, can we waive Miranda? Of course we can. Our defendants can waive their rights, and any waiver must be knowing and voluntary. And in order for that to happen, they must be communicated. But along the way, our clients from time to time assert their Miranda rights. You can assert your Miranda rights two ways. One by silence, one by asking for an attorney. So if you in fact say, I do not wish to talk to you, do the police have an obligation at that time to respect that? The answer is yes. They have to, quote, scrupulously honor the person's right to remain silent. Scrupulously honor. You scrupulously honor by stopping, times involved, rewarn the person, and usually a new offense. If that happens, then you can talk to the person. If in fact they claim they have a right to a lawyer and they want a lawyer, is it ambiguous or unambiguous? If it's ambiguous, the court's going to say no to the person asking for a lawyer because we didn't know what the person wanted. If it's unambiguous, I want a lawyer, that the police cannot talk to him after that for any reason. So what's the greater protection? Your client saying, I want a lawyer. Sixth Amendment right to counsel. In the Sixth Amendment right to counsel, it occurs not during arrest, but during a critical stage. A critical stage of the proceeding, clients have a right to an attorney. Now, the question is, what do we mean by a critical stage? And normally we're going to say judicial proceedings. First time coming to court, they have a right to have an attorney. Also, if in fact it's a lineup after an indictment. So you come to court with one procedure, and then they do a lineup after you've been to court. You have a right to be present. Now, when is the Sixth Amendment violated? Well, the Sixth Amendment is violated after the initiation of judicial proceedings, deliberately eliciting, after the initial initiation of judicial proceedings, and after that you have begun. An arrest does not trigger instead an arraignment or indictment. This means custody is irrelevant in the Sixth Amendment issue. unlike Miranda, the Sixth Amendment is not tied to custody. It's tied to offense specific. And what offense specific means is that the officer who is the defendant who's arrested for burglary claims to have the Sixth Amendment and says, I don't want to talk, and then the officer wants to talk to him about a killing. They can come down and talk to him about the killing, even though the person said, I don't want to talk to you about the burglary, because it's offense specific. When do the two overlap? That's the Blockberger test. I want you guys thinking that it happens to almost be identical. And think of a case where burglary and trespass. In order for a person to show burglary, you have to at least be able to show didn't have a right to be there, trespass. And so the trespass really is going to be part of the burglary, and it's all right. So it's part of it. If that's the case, then you would say it's one and the same offense. And I may have to go a few more minutes, right? Fifth Amendment non-Miranda. When does the Fifth Amendment non-Miranda apply? That has to do with compelled self-incrimination. It applies to people, not corporations. And it requires potential criminal consequences. Even though there's a tough situation where you have to give over documents, there may be a fifth, there may not be a Fifth Amendment issue. And also, it has to be testimonial. And that is, evidence must be testimonial in nature. Who can waive this, or who does this Fifth Amendment apply to? The defendant in the criminal cases, as well as a witness, but a witness versus the defendant. Does the defendant have to claim the Fifth Amendment? Can they be compelled to testify? No. A witness is compelled to testify. They have to assert the Fifth Amendment privilege. Double jeopardy. Double jeopardy involves two crimes of the same offense. Okay, when does double jeopardy attach? Double jeopardy attaches in a jury trial when all the panel of jurors have been sworn and they're ready. In a court trial when the judge calls the first witness. Right to counsel. When does the right to counsel occur? Right to counsel occurs still at a critical stage. It occurs at a lineup after judicial proceedings. The right to counsel for felonies, judicial proceedings. Felonies is Gideon. We had the 50-year last year anniversary of Gideon. Misdemeanors. Misdemeanors, not only is it actual jail time, but suspended time. Sheldon v. Alabama. That came down in 2013. Guilty pleas and the others. Does the taking of blood, handwriting samples, pre-investigative charge lineups, photo lineups, do those require lawyer? The answer is no. Conflicts of interest. Well, this goes first. Lawyer conduct. How does the lawyer act? Strickland is the case. If you get lawyer conduct, Strickland is a two-pronged test. And the two-pronged test is one, that the action of the lawyer was completely below the standard for lawyers' conduct, and the result was so dramatic as to be prejudicial to the defendant. In the Vicky case, there was the co-defendant talking, and when the co-defendant gives a statement to apply to another co-defendant, you're going to get into a randa bruton issue, and that is, in order for the statement to come in, it has to be redacted in such a way that one defendant doesn't show that it's referring to another defendant. So if you can remove names and it's not obvious, then the answer is yes. But if you remove names and put third persons he or she, but it's clearly obvious that the he and she is the person sitting right next to you, you would argue that a randa bruton is still being violated. If in fact the defendant testifies who gave the confession, then the opposing party has the right to cross-examine, and a randa bruton would not apply. But if in fact generally speaking at the beginning, how do you protect with multiple defendants who give confessions back and forth? How do you protect? Well, you can protect three ways. You can sever counts that the confession's related to. You can sever the defendants from trial. Or you can have separate juries that hear the individual statements. Right to trial by jury. 12 is 12 jurors a constitutional requirement? No. What about 11? Can a decision of 11 to 1 be okay? Does it require unanimity? No. 11 to 1 is okay. 10 to 2, 9 to 3 is okay. 8 to 4 is too far. The answer is no. Now, on unanimous, if in fact it's less than, if it's 6 or less, the answer is it must be unanimous. But just think, there could be states that have 6 jurors. And that's constitutionally okay. There is an issue with the crossover con law. If you're picking a jury, and in picking the jury, one side uses peremptory challenges for excusing them for their own reason, but they have racial, gender, sexual preference biases, we can raise those issues and claim the conduct of excusing those people were wrong and prevent that juror from being excused. In a situation where bias is shown, you have the burden to show the bias. If you can show it, then the burden will shift to the other side to show race-neutral reasons. If they can come up with race-neutral reasons, then their conduct will be okay. And then we have the cruel and unusual Eighth Amendment. There was one a year or 2 years ago on the Eighth Amendment, cruel and unusual. As long as you look at that and you look at the cruel and unusual issue, if it involves the death penalty, look to see whether there is automatic imposition of death on certain jury. In other words, if the jury finds a particular issue, then it's automatic death. Anytime you see automatic, it's a red flag and you want to strike that down. The death penalty may not be imposed where the defendant had no intent to kill or did not participate in a substantial factor in the killing. Substantial factor would be a pretty big one, right? That could be an aider and abettor who, the argument is that they substantially participate in the killing. Okay, why don't we end there? Let's talk Vicky. Now, you know, we have talked Vicky, right? We've been discussing Vicky as we went along. The fascinating thing about Vicky is there's 3 calls of the question. That should tell you immediately how much time can I possibly devote to conspiracy and murder if I got 3 calls of the question. So what they want you to do is they want you to get in and get out, right? So therefore, if in a question like this, you're getting into the issue of conspiracy, we're going to go right to conspiracy, okay? We're going to go right to it, we're going to define it, and we're going to try to identify the issue that the facts are raising, resolve that issue, and move on. Because we then have to go to the issue of murder. And if you look at the call of the question number 2, they want you talking first or second degree. Did they ask you and for any other lessers? No. Do they want you talking voluntary or involuntary manslaughter? No. They want you talking first or second. So you got to get right into it. Now, what's the interesting thing that you should recognize? It's kidnapping. Therefore, kidnapping would be circled. You'd put it on your scratch paper, right? You'd put the felony murder rule, and you'd remember to get into it. And the first time you go to malice, you'd be talking the felony murder rule. You get right to it. Now, on the conspiracy side, we have the definition of conspiracy, and then we have the agreement. And wouldn't you agree that we have a pretty obvious agreement here in the Vicky? But we want the person to tell us about that agreement, and then we want you to identify that it was done with a specific intent to agree. And the underlying objective was to kidnap for ransom. And kidnap for ransom is a good time to talk about what kidnap is. Right then and there, you can start mentioning kidnap. Although you're talking conspiracy, the object is the kidnapping. And in the kidnapping, we're going to talk that it's aggravated because it's ransom. Being aggravated kidnapping, not only do we require no consent and we require movement, but we have the specific intent of requesting ransom in this particular case. So it is a higher elevated kidnapping. Was there the intent? Clearly there was the intent to agree with the object. Then the issue now, in that particular case, they're asking you on what theory liability might Bill be convicted for rape. So in that situation, although the object of the conspiracy was kidnapping, the question that they're asking is would that person be criminally responsible for rape under conspiracy? And what you would talk about, the elements of the conspiracy, talk about that the object of it was kidnapping, the object was not rape. On the other hand, one could argue that perhaps rape might be an object of the conspiracy if it was designed to intimidate the woman into not leaving, but she would be so emotionally intimidated that she would comply with whatever demands they have. Then theory could be it may be an object of the conspiracy. The better reasoned answer would be it is not an object of the conspiracy. Question, under liability for conspiracy, under liability, is it foreseeable? One, yeah, it's foreseeable because they talked about it and they actually knew the person had been convicted, so it's foreseeable. But is it in the furtherance of the conspiracy? And that argument's probably no, it's not in the furtherance of it, but you would talk about it both ways, but the more reasoned answer would be no, it's not in the furtherance of the conspiracy. It's just some homicidal sex maniac who's going off on poor Vicky. Second, after we talk conspiracy, we'll go to accomplice. Now, the distinction between accomplice and conspiracy on the issue of liability that we talked earlier is that under foreseeability, there's no second requirement that it be in the furtherance of any aiding and abetting. It's just whether it's foreseeable. And I think all of us could write a nice argument for why we believe the rape is foreseeable based on the facts. The defense would be withdrawal. The guy Bill went to the police to withdraw. Under withdrawal, though, basically in withdrawing, you are voluntarily withdrawing before the crime occurs. Here, the conspiracy had already taken place, even though the conspiracy may not be an issue for liability, but under aiding and abetting, the crime had already taken place. Did he withdraw from the kidnapping or the rape? The answer would be that it already happened. The kidnapping and rape had already happened. Matter of fact, I think she already had killed herself when he found out. So all the crimes had occurred. Since the withdrawal was done after the crimes had occurred, then it wouldn't be successful. However, if it had been done before the crimes occurred, was it voluntarily withdrew, and did the person go out of their way to stop the crime? Here they did talk about, at least they went to the police, but since the crime had already occurred, he would be responsible under the theory of aiding and abetting for rape. Okay, the murder. In the murder, you want to get right to it because, like I said, this is not one where you get to develop a whole lot. You got 3 calls to the question, and we would quickly identify whether Art and Bill or either of them can be guilty of murder, first or second, for Vicky. We would define murder. We'd get right into it. We'd talk first degree, and under first degree, we would discuss the definition of first degree. Remember now, there's about 3 different first degrees. First degree for intent to kill coupled with premeditation and deliberation. First degree for felony murder rule, kidnapping. First degree for the special bombing, torture, poisoning, ambush. Here we would talk about we would talk about intent to kill coupled with premeditation and deliberation, and talk about whether or not that was established. Second thing we would do is we would talk about the felony murder rule. Now, in the felony murder rule, the kidnapping and rape are inherently dangerous felonies, right? Modernly kidnapping, but common law, rape was inherently dangerous. The question would be was the rape done in a foreseeable causation way? And causation would be a good issue. So if you have causation, don't just be distracted with homicide in this one. You want the causation right under the felony murder rule. And talk about the fact that but for this action, that she never would have killed herself but for the kidnapping and then the additional rape. And further, is it foreseeable that someone might harm themselves? I think it's foreseeable that somebody might harm themselves to get out of the situation they're in. And what if they went too far and they killed themselves? It's just, you want to stop the pain, and so killing yourself might be a foreseeable action. Now, the second degree, in second degree murder, remember, it's anything that's not premeditation, deliberation. So in the second degree, it can be intent to kill, GBI, it can be wanton and reckless disregard to life. Can't be felony murder unless it's a non-felony murder, inherently dangerous felony, but we don't have that. So since we don't have a second degree non-inherently dangerous felony, we're going to have the issue of whether or not these particular conduct was a wanton and reckless disregard to life. And I think the argument can be yes. And I think that therefore second degree murder, although they say second degree murder is not applicable, I think we could argue, did the killing occur during a wanton and reckless disregard to life? Would it be wanton and reckless disregard to life to put somebody in a situation where perhaps kidnapping them and then raping them? I think you could argue a wanton and reckless disregard to life. If the second degree murder was for the purpose of second degree felony murder, do we have a non-felony other than kidnap and rape? No, so we don't have a non-inherently dangerous felony. If there was fleeing from the police along with, let's say, kidnapping, and the woman, Vicky, was still in the car, we then would have a righteous second degree felony murder, because the issue would be whether or not fleeing from the police is inherently dangerous. And it has to be inherently dangerous by nature. So can you flee from the police in a non-inherently dangerous way? Can we drive 30 miles an hour and flee from the police? Yeah. Is that inherently dangerous to life, driving 30 miles an hour in a 1965 Volkswagen? Probably not. So therefore, look to the underlying nature of the offense. Is it in and of itself inherently dangerous? Furnishing drugs to somebody, is that inherently dangerous to life? It can be. That's how Belushi and a lot of other people died, right? But hey, how often do people get furnished drugs? Every person who uses drugs got furnished it, right? So is furnishing drugs inherently dangerous to life? No. Can it be done in an inherently dangerous way? Yes, but that's not the standard by its nature. And then the third issue was the Bruton Aranda Fifth Amendment. That is Bill's statement to the police. Okay? Now, under the Fifth Amendment, did Bill come into the police station on his own? Okay? And did he talk to them voluntarily? Is there any custody and interrogation here? No. The argument would be there's no custody and interrogation. If they stop him and say, wait a minute, we're arresting you, and now want to further talk to him, now we got a custody interrogation. But when he comes down and says, hey, I got stuff on my chest, I got to talk to you, and he starts talking, he's freely and voluntarily doing that. So really, there's no Fifth Amendment. Then the question comes, is there any Sixth Amendment right to confront? Defendant has a right to confront his accuser. Right of confrontation prohibits use of a statement of two persons who are charged with the same offense. That's Aranda Bruton. How do we clean up the statement of Bill and Art so that Bill's statement can come in against Art. Bill's statement's coming in against Bill, right? We don't have an issue on that. We know that's coming in against the person that makes it. But what about Art? Well, the way it would come in is, can we redact those statements relating to Art in such a way that it doesn't point to Art as being the person that Bill's talking about? If it can be redacted, then redact it. If it cannot be redacted, then we have to say the statement can't come in. And how do we then handle that? Separate trials, separate counts, if we could somehow separate counts, separate juries. And if you think about it, with a case like this, with a question like this, Vicki, if you gave yourself 5 to 10 minutes to analyze it, you're left with, say, 50 minutes. And wouldn't you want to at least spend 20 minutes on the conspiracy and 20 minutes on the murder? That leaves you 10 minutes for number 3. And 10 minutes for number 3, as you can see, really allows you to get in and get out. It's not a throwaway. It's not throwaway. But it's probably a 15-pointer compared to the other two. Maybe a 20-pointer, where the other two are probably 40 and 40. So this one, it's 3. Now, when you get 3 calls of the question, you know one of them isn't going to be requiring as much. And you should have seen immediately that this was the two people statement coming in against each other. Identify the Aranda Bruton issue. Talk about how you can clean it up and what's the remedy for it. Okay. I still have 10 minutes. Now, with the 10 minutes, let's do this. Let's just throw it open to any question you guys have on any issue we've talked about, or that you would like me to talk about that I haven't. Yes. Yeah, it's a cruel and unusual. The what? Okay, well, let's just basically, since you mentioned the Eighth Amendment, let's kind of go back to that a little bit. In the outline, when we talk about the Eighth Amendment issues related to criminal procedure, we're usually talking about the cruel and unusual punishment and the death penalty. That's usually why they bring up the Eighth Amendment. But for instance, you say cruel punishment. A really good example, wouldn't that be, do you remember years ago the caning in Malaysia? Yeah. And they caned the person on the back. Now in the United States, do we allow caning? The answer is no. Might that caning be what we would call cruel and unusual? And we could argue yes, because the punishment is so what? Disproportionate to stealing? That you would beat somebody with the cane unmercifully? Okay. But otherwise, we're looking to whether or not the death penalty is going to automatically be imposed. If the death penalty is automatically to be imposed, there is no discretion by the jury. We would argue that's cruel and unusual, should not be allowed. Then the next thing under the cruel and unusual is the defendant being charged with the death penalty, even though we did not establish intent to kill, or they played a substantial role. Did they participate in a substantial way in the killing? That case is taken from a case out of Arizona Supreme Court, where the son of a convicted killer lets dad escape. And when they escape, there's 3 of them. The guy who helped dad and his buddy escape. They're then out on some farm area and they stop a car with a husband, wife, and 2 children. Really brutal. And the guy who was the son was fairly young, so he went up to the car and said, hey, we need help. As soon as they stopped and tried to help the other 2 come in, the homicidal maniac, come in. All 4 of the people are brutally killed at their house. And the question is, did the son play a substantial role in that particular case? And the court said yes, and was subjected to the death penalty. Okay, that's the Eighth Amendment. Yes? Burglary, there is habitation, and that's what burglary is for. Okay, that is a residential home, house, okay, that people live in. It's the breaking, entering the dwelling house of another with the intent to permanently, with the intent to permanently deprive. It's the breaking and entering the dwelling house at night with the intent to commit a theft or felony therein. Habitation. Under California, though, we apply it to commercial establishments. Under the modern statute, and you're going to say that it's a minority of jurisdictions, and under a minority, it can come in. What's the second question?
The second question was, I kind of got lost on the search. You said that, I forget which case it was, that you said that the government puts a tracking device.
Yeah, okay, let's talk tracking device. A tracking device, okay? 3 cases they got involved with. Knott, Caro, Jones. Those 3 cases, all right? Knott, a tracking device was put inside a container that the defendant had, and they surreptitiously put this tracking device inside the container. The defendant then took the container and put it in his car. They then, the police, tracked the movement of the car on the street. Knott. Okay? Caro, same thing happened. Container, defendant puts it in the car. Then in Caro, the guy takes the bag and walks to the house. From the house, they monitor the tracking. Like Kelo, monitoring it from the house, that was determined to be unlawful without a search warrant because it invaded the home. Kelo, the enhancement device, was invading the home, was not allowed. Jones. Now in Jones, another tracking device, but this tracking device wasn't put in a container where the defendant put it in his own car voluntarily. This tracking device was installed on the undercarriage of the car by the police. Trespass to the car.
So my only question would be, so it's okay to put something into a container?
It's okay to track through a beeper movement on the street because you can otherwise surveil the same way. Yes. Yes. Call the question.
Murder?
Yes.
So basically, unless it says first degree or lesser crimes, that's the only time you bring up voluntary involvement.
Yes. Well,
If it says first or second degree.
well, listen, that's right. In Vicky, you wouldn't bring it up, right?
Yeah.
But it might not say that. It might just say whether or not the defendant could be, like another question could say, would the defendant be responsible for the death of Vicky? Now, what are they?
Not all of it?
Now, with that's wide open, right? Yeah, you got to talk about it all. Now, but if they limit it, which they're good at doing, they want to limit it. They're cool about that because they give it away. They tell you first and second, and you're in heaven. You don't even have to.
Something like first and second and any defense.
Well, if they, but you're almost always going to get into an issue of defense if it impacts the conviction of first or second degree. Because the defense might be that the felony murder can't be established, and that would be a defense to the first degree. If there's a righteous defense of necessity, for instance, or something, you could bring that up as to undermine the first degree intent, premeditation, and deliberation. Although, and then you might say it might apply to the second. Yeah, but usually they're really good about telling you. It's so cool. They're so good about telling you what crimes they want you to discuss and what piece of evidence they want to keep out. We want to keep out the chalk. How do we keep it out? You know, it's criminal pro. It's so cool. Can you be held responsible for the theft of the chalk? Then you know immediately they're talking about one of the 4, and they want you to identify one of the 4: larceny, embezzlement, larceny by trick, or false pretenses. It's cool. You guys should love it. If you get a crim law, crim pro, and you get a dead body on the exam, and it happens to be the first one, you know the Toyota commercial where you jump up and kick your feet? Jump up and kick your feet because you're nailing it. You are nailing it if you simply go through the approach on the first degree into second degree. If it's lessers, Don't forget, voluntary and end with involuntary manslaughter. And if you go through all 4 of those, you're going to do well. And then there's probably going to be an issue as to whether the gun can be admissible. And then you're going to talk about the 4th, whether or not maybe the 5th came in because the statement led to the gun. Maybe there's a 6th or a 14th. Chances are, if it's a gun, it's going to be pure 4th. And you're going to look and you're going to say, 4th Amendment applies to the states through the 14th. You're going to put the gun, you're going to get right into it, you're going to talk whether or not there's state action. If there's state action, if it says the cops in Long Beach, there's no state action. So just blow it off, okay? If they don't tell you police agency and you're concerned because there's an agent or something, then you have a righteous state action issue. Otherwise, you don't have a righteous state action issue. Don't talk about it. Because if it gives it away and says the FBI, hasn't it just told you state action? Sure. So just talk about the state action. Don't talk about state action if it's given to you. Just get right into whether or not there's a search, whether or not it was a warrant or not. If there's a warrant, talk about warrant. If there's no warrant, go right into the warrantless exception. Don't even talk about warrant. We don't want to talk about extraneous things that aren't present, right? Because it's difficult enough talking about what is present. So you look to the warrantless exception, you identify as many of the warrantless exceptions as you can, and you're always talking about whether it's reasonable or not. Then you're going to look to the exclusionary rule, because very likely a sub-issue under the 4th may be whether the exclusionary rule applies. And then you're going to get into the issues of attenuation, whether or not we can show that it was attenuated, whether or not we can show that it was inevitable discovery, all right? The reasons for why the exclusionary rule would not apply. Impeachment, if there's impeachment, okay? And go through the list of the reasons under the exclusionary rule why it wouldn't apply. Yes, Ann. Right. Get right to what they tell you. And if it's call the question 1, can Art be convicted of rape? Right on your page. Can Art be convicted of rape? Underline, go through it. Give them right back what they ask. Okay? Call the question 2. Can he be convicted of 1st or 2nd degree murder? Underline it right on your page and talk 1st degree. Boom. And then later on talk 2nd degree. Underline it. Talk about it. 3rd. Boom, 2, 3. Can the statement by Bill come in against Art? Underline, get right into it. And just say, hey, the issue here is whether or not a random Bruton's going to apply for a co-defendant confessing where it can come in against another defendant. In this particular case, boom, and then get into it. Give them right what they ask you. Anything else? I feel like there should be. Don't you? Don't you feel like there should be more? Well, the cool thing, I will end with this. The cool thing about criminal law and criminal pro is it can help you become an attorney on the bar exam because you can nail it. And the chances are you're not blowing a crim law, crim pro question. Don't panic. You're not going to blow it. Leave the panic for property or something. Not crim law, crim pro, right? Because you guys are going to nail it. And I know with Sherry, she's going to have a real good approach for you guys with real property and all the other classes. But crim law, crim pro is not going to prevent you guys from being a lawyer. You understand? It's going to help you because you're not going to just get a 72, 3, 4, 5. You're going to get an 85 or more. And you're going to be on fire. And hopefully you'll be the first one, and doggone it, hopefully you'll be a dead body. Don't panic with the dead body. With the dead body, you know what they want from you. We haven't had enough dead bodies in a while. Maybe the last one I think was Vicky. But we haven't had many dead bodies. So what does that tell us? I think we're getting a dead body. What do you guys think? I think so. You guys want a dead body. Everybody on camera wants a dead body. We want a dead body, and we're going to nail it because we're going to take the approach. Thank you, everybody.